Okay, my next case is Andrew 2040-2730. Good morning.
Happy New Year.
Happy New Year. We're set for a pretrial readiness date. Are you ready for trial on the 15th?
I am.
Okay. And Mr. Myers, is this your case?
It is, Your Honor.
Are you ready for trial?
The people also are announcing ready for trial.
For the prosecution, any pretrial issues that we need to take up?
Just one thing from the people, Your Honor. I'm not sure if it's a pretrial issue. From what I'm seeing, I'm not 100% sure if Andrew has come to our office to pick up discovery yet. And so I just wanted to get kind of an update on that. We can give him the sheet again today, just so that we're not there the morning of trial, kind of showing the discovery in the case.
I just want to make sure that I've done a full Arguello advisement as well, because I think we had. All right, I don't think I have, so I'm just going to make sure, Andrew, that you understand. This is an advisement I'm required to give if someone decides to represent themselves. And so I just want to make sure that the record's clear. All right. That you are making a choice to represent yourself. So do you understand that you have a right to represent, be represented by counsel throughout this case?
I've been told that.
Well, thank you very much.
As far as the benefit or firsthand knowledge of communicating with any legal professionals on the matter, I really don't have experience on the matter to speak and say, yeah, I understand what that would. But I don't want to cause controversy, and I don't want to be belligerent or cause dishonor in your courtroom. And I hope that because we've all known each other firsthand since July 1st of last year, I hope that I haven't done that ever in your courtroom.
Okay, so I have some questions under the law I have to ask, so I just need to make sure that the record's clear. So do you understand that if you cannot afford an attorney, then one could be provided to you free of charge? Do you understand that? So that would be the public defender?
Okay, I comprehend that.
Okay. And so the process for applying to public defender would be you'd go over to their office, you'd fill out an application. They'd say if you make below a certain amount, then you could have that attorney appointed. Do you understand that?
Someone like Miss Alika Johnston.
Johnston, yeah. She works for the public defender's office.
Absolutely.
Okay. And so these are just questions I have to ask under the law. So I'm not trying to quiz you, but do you have any legal training?
For like, did I go to law school or?
Do you have any legal training at all? Any legal?
This is a full-blown sovereign citizen ideology collision with the criminal justice system. The defendant believes that following state law, having a driver's license, and even carrying insurance violates his religious beliefs and what he calls God's law. And that belief is exactly why he's standing alone today, representing himself, facing real criminal exposure, and about to head toward a jury trial without a lawyer. This is his final pretrial hearing, the last stop before everything becomes very real in front of 12 jurors who do not live in the sovereign citizen echo chamber. What makes this especially risky is that the judge is about to walk him through a full advisement process, laying out penalties, rights, and consequences, and every answer he gives matters. The tension here isn't loud yelling or chaos. It's watching someone confidently walk toward a legal cliff while insisting the ground beneath them doesn't exist. And as this hearing unfolds, pay close attention to how belief, misunderstanding, and reality start colliding, because this case is a textbook example of how ideology doesn't survive contact with the courtroom.
Okay. And then for the failure to display proof of insurance, you're facing a maximum sentence of a year in jail, $1,000 fine. There is a mandatory minimum fine depending on how many priors you have. It's either $500 mandatory minimum fine or $1,000 mandatory minimum fine, although the court can half those mandatory minimum fines if you provide proof of current insurance. Driving under suspension is a traffic infraction, and as well as expired license plates. So you're facing up to $100 fine on those cases. Do you understand the possible penalties that you're facing?
Yeah, what you're telling me.
Okay. How far have you gone in school?
Away.
All the way?
All the way.
Do you mean you graduated from?
Public school?
Yeah, this, how far have you gone in school?
Well, before 2020, I was known as a master electrician. So I had completed, some stuff with Emily Griffith and had even a license as a master electrician, and was at that time, purporting myself to be an electrical contractor,
Okay. So did you graduate from high school
I
or
have,
get your GED
I have a
or
diploma from.
you have a diploma from your high school? Okay. And then Emily Griffith, for the record, is a trade school, but can also have like a secondary school beyond high school. Is
Right.
that right? Okay. All right. And then are you under the influence of any drugs, medication, or alcohol that would affect your understanding of today's proceedings?
I am not.
Okay. Do you understand that criminal law is a complicated area and that an attorney trained in this field could be of great help in preparing and representing your defense?
Criminal law. Is this criminal case?
This is a criminal case.
Okay. I comprehend that.
Okay. And do you understand that you have a right to remain silent and that anything you say can be used against you in court?
I do not understand that because I was compelled to participate in the competency evaluation. And when they said they called, and, I really have honest phone records from Comcast, whether anyone called or left a voicemail, and they didn't call the number that we provided them. And I went to jail for that for 3 days because I didn't want it to, I wanted to remain silent and not testify against myself, but they contracted a psychologist from Canada who works on a case-by-case basis. And she basically, made me uncomfortable and threatened me and said if I'd already gone to jail for 3 days because somebody said they left a voicemail. And I didn't want to testify against myself. So as far as the right to remain silent with someone threatening me to go back to jail with like a gun in my head, I am forced to go against my.
This moment right here is subtle but incredibly important. The prosecutor casually raises the issue of discovery, the evidence in the case, and whether the defendant has even picked it up yet. For represented defendants, discovery is automatic, handled by counsel, organized, reviewed, and explained. But when you represent yourself, you become responsible for every procedural step. And here's the problem. Courts don't bend timelines or evidentiary rules just because someone refuses to cooperate with standard processes like showing ID or signing paperwork. The judge now launches into a required advisement, not because she's suspicious, but because the law demands it. This is the court protecting the record, ensuring that when this goes to trial, the defendant can't claim he didn't understand his rights. What we're seeing is the system bending over backwards to give clarity, while the defendant frames routine safeguards as pressure or coercion. This is the exact moment where self-representation stops being philosophical and starts becoming dangerous.
Okay. So in trial, what will happen is if you make statements, the jury can take that in consideration of what statements you're making. So during trial, if you have an opportunity to testify, and we'll talk about that in the middle of trial once there's that time for any defense case. But any statements you make in court in front of the jury, those could be used against you. Do you understand?
And I really didn't come here today either to make any statements. I didn't know that we were going to have questioning like this.
Yeah.
Where I'm still, all these questions that you're asking me, I'm answering them under duress.
Okay.
Because I'm supposed to be downstairs with Judge Gorman 7 minutes ago over the exact same stuff, and I've already done some time, and I don't want to cause dishonor. I don't want to cause controversy. I am seeking to correct my status, and I'm here by special appearance. I don't know what a fashion plea is, and last time I was with you, I was going to ask, you said a word to me if I found anything, and you used this word, and I was about to ask you what that word was or what it meant, and then that's when Mr. Myers approached me with the discovery. And so
Mhm.
I was still trying to focus on what we were talking about or what you were saying. Do you remember what that word was? It was about if I found anything in the time that when we'd last seen each other. And I think the word started with the D, and it was like dis.
This analogy from the judge is one of the most accurate and telling comparisons you'll hear in any self-representation case. The court asks a simple, factual question. Do you have legal training? The answer is no. And yet, the defendant continues to operate as though legal procedure, evidentiary rules, and courtroom strategy are optional. The surgery analogy cuts right to the heart of the issue. Nobody would willingly perform surgery on themselves without training, yet people regularly gamble their freedom doing exactly that in court. What makes this especially risky is that criminal trials are unforgiving environments. There are objections, foundational rules, burdens of proof, jury instructions, and missing just one procedural step can sink a defense entirely. The judge isn't insulting him here, she's warning him. But ideology often convinces people that knowledge is unnecessary, that belief substitutes for training. And that's how defendants talk themselves into convictions without realizing it.
Something. Did you find any? I trust that it was like a question, but it was you were saying, I trust that you didn't find any. And
I don't
can't
remember what I said,
And
but
then that's right when Ian came up to me and
so let me just ask you these questions then. So so it sounds like you understand that at trial, if you decide to speak, that those words can be used against you. These are questions I'm required to ask because you're representing yourself. And I'll talk about the process for trial. But you should understand that you have a right to represent yourself, but by doing so, you take a great risk of not properly presenting your case. And so do you understand that you have a right to confront the witnesses against you and cross-examine them? So in trial, the way that would work is if the prosecution calls a witness to testify, that person would get sworn in. The prosecution would ask those people questions, and then they would sit down, and their direct examination would end. That would be an opportunity then to cross-examine them or ask questions. So you don't have to cross-examine someone. The burden of proof is on the prosecution, which means that they have to prove this case beyond a reasonable doubt. You're not required to ask questions, but you do have a right to ask questions of those witnesses.
I could depose these witnesses, basically.
Well, we don't use the term depose, but you can ask them questions. Okay. And so you can ask them questions under the law as part of the trial. Do you understand that? Okay. And do you understand that you have a right to have witnesses you choose compelled to appear and testify on your behalf? So if you believe that someone, you'd like to bring in a witness, I'm not sure if there was anyone there with you on that day, but if there's someone that would come voluntarily, you can just ask them to come in and they could testify on your behalf. If you want someone to receive a court order, there is a process that you would go in. You'd file something with the clerk's office asking me to approve those subpoenas. If I approve them, then you would have someone not related to the case serve them. So you could have a private process server or the sheriff's office serve them and say, this is a court order to come to my trial. You could also have a third party not related to the case serve those people and ask that they be here. So do you understand that you have the right to have witnesses you choose court ordered to be here and testify on your behalf?
What do you think the likelihood would be of us summoning the Attorney General of the state of Colorado or the Registrar General of the state of Colorado, if that's relevant to the ultimate facts that got me to make the mistake that I made?
This is where the conversation shifts from theory to consequences. Jail time, mandatory fines, criminal convictions. These aren't symbolic penalties or administrative slaps on the wrist. These are real outcomes with real-world fallout. And notice how carefully the judge explains each charge, breaking down what's mandatory and what could potentially be reduced. This isn't intimidation, it's transparency. Courts do this so no one can later claim they were blindsided. But here's the danger. When someone believes the law doesn't apply to them, they often don't emotionally process these warnings. They hear numbers, not consequences. A year in jail sounds abstract, until you're sentenced. A mandatory fine sounds negotiable, until it isn't. This advisement is the court saying, if you proceed this way, this is exactly what you're risking. And at trial, the jury will not be evaluating belief systems. They'll be evaluating evidence.
So you can always file something in writing, and then because you're not represented by an attorney can issue those subpoenas, but because you're representing yourself, you have to file something with the court, make grounds as to why you believe that the court should approve that subpoena. And so I would say I've never seen the Attorney General for Colorado come in and testify on a traffic case. You can always file something in writing and I can take a look at it. And let me just correct the record. Okay, go ahead.
Can I do that as the authorized representative of Andrew Lawrence?
I know that you are appearing today as if you are representing you're the authorized representative.
I'm here making a special
Mhm.
appearance. I've come here to do that.
So you can file whatever you'd like if you believe that someone can support your case, and then I'll file something in writing. That's the cleanest way to do that. I just want to clarify, I guess I said it was driving under restraint, but you're charged with driving without a valid driver's license. And let me just confirm that.
I was wondering if that was appealed to something different
Okay,
when Mr. Myers came up at our last meeting.
they need to file something in writing then. So you're moving to amend the no valid operator's license?
Your Honor, if the court wants me to write a written motion, I can totally do that.
Okay. So currently you're charged with driving under restraint. The prosecution is moving to amend it to driving without a valid driver's license. So driving under restraint means that your license has been suspended. What this charge is that they're moving to amend is to driving without a valid driver's license, which is a different charge. Do you have a position on that motion?
I haven't been offered a plea as
Okay.
far as making a decision on it.
Okay. So that no valid operator's license comes with a maximum sentence of a $300 fine, 90 days in jail. That's the maximum sentence. So I just want to explain to you kind of what you're facing. And then we've gone through that long advisement about representing yourself. Based on my advisement, do you still wish to represent yourself?
I'm not sure of the legal implications of me using the word myself. You know, and when I'm looking at pro se, it's is it he speaks for himself?
So are you making a knowing decision to not use an attorney in this case?
Based on, yes, based on what the Bible tells me that Jesus says about attorneys. No offense to anyone.
This background explanation is fascinating because it reveals a recurring theme in sovereign citizen cases. Competence in one field being mistaken for competence in another. Being a licensed electrician requires training, certification, and adherence to regulation, the very thing this defendant claims to oppose in other areas. There's an irony here that's impossible to ignore. He accepted oversight, licensing, and compliance when it benefited his profession, but rejects those same concepts when applied to driving in public law. The court, however, isn't judging his intelligence or work history, it's establishing competency. Education, sobriety, mental clarity, all boxes the judge must check to ensure this defendant is knowingly making these choices. And once those boxes are checked, the responsibility shifts squarely onto him. From this point forward, any misstep at trial becomes his alone.
Okay. All right. So I'm going to find that your decision to, as I deem it, represent yourself because you're not using the public defender, you're not hiring an attorney, is made knowingly, voluntarily, and intelligently after a full advisal of your rights that you have in this matter. I've explained how to have a subpoena based on my observations of Andrew. I make a determination that he, based on his demeanor today, he does understand everything that I've just advised him of. And so I will find the waiver of counsel been made knowingly, voluntarily, and intelligently. So the prosecution has said you have not picked up discovery, which is the evidence in the case. So we can give you information to do that, but so that there aren't any surprises on the day of trial, you should go there today to pick up that discovery and make sure that you have that so that you're prepared, okay?
Okay. I do have another case.
In front of Judge Goman, yeah. We let them know that you'll be late.
If anything goes wrong in there, how would I get the discovery? Say I was put in the dungeon?